Broadcast has started. Good morning. In this meeting, we have the members of the Public Council of International Experts, members of the High Qualification Commission of Judges of Ukraine, these are the names of the members of the Commission. I'm Andrei Pashchnik. I'm chairing this meeting. We have the quorum. It's a special joint meeting of the High Qualification Commission of Judges of Ukraine and the Public Council of International Experts. This joint meeting is broadcast live. The number of issues that we have to discuss, first on suitability of the candidates for the positions of the High Anti-Corruption Court of Ukraine with Article 8 of the Law of Ukraine on the High Anti-Corruption Court. We have three candidates: Kotelva Kateryna, Olena Chernova, Kirill Lehkich. Are there any proposals? Dear colleagues, because of the office duties, because I need to go away on a business trip, please allow Ms. Chernova to be the second one, because I am the spokesman for both Ms. Kotelva and Ms. Chernova. Colleagues, would anyone object? Dear members of the PCIE, is that okay with you if we change the order of the candidates? Thank you. So we are voting the proposal of the member of the Commission, Serhiy Chumak. So we change the order of the candidates that we're going to hear today. Who's for that? Please vote. Members of the Council, can you please vote? If you approve it, support it. Thank you. The Secretariat of the Commission, please inform us about whether the candidates are present. The invited candidates have arrived here, namely Kateryna Kotelva, Kirill Lehkich, and Olena Chernova. Thank you. Please invite Kateryna Kotelva to the room. Good morning. We're to discuss the issue of whether Kateryna Kotelva suits the criteria of Article 8 of the Law of Ukraine with the High Anti-Corruption Court. We have here the members of the Public Council of International Experts: Gabriela Yatkaita-Kraskiene, Norman Us, Robert Hyberkheisen, Jessica Law Thompson, John J. Sullivan, members of the High Qualification Commission of Judges of Ukraine. You have the right to suggest that some members of the Commission be recused. Provide your comments. With permission of the chairman, express your comments and proposals and appeal the decision of the Commission. In this joint special commission, we are not to discuss any new material submitted by the candidate if he or she has had a possibility to submit them earlier. If there are any circumstances that can have serious effect on the decision of the Commission on the initiative with support of at least 3 members of the Commission and the Council, the decision can be made to add the additional materials to the previously submitted documents. Would you have any suggestion to recuse any member of the Commission? No. Would you have any motions? No. Thank you. The spokesman in this issue is Serhiy Chumak, member of the Commission. Thank you. Good morning, Kateryna. I will make a brief report, whereupon we will proceed to the questions to be put by the PCIe and the HQCJ. So, Kateryna has graduated from Donetsk University in 2002. 2004, she graduated from the National Academy of the State Tax Service of Ukraine. With the decree of the President of Ukraine of 2013, English Kotelva was appointed as judge of Voroshilov District Court of the city of Donetsk for 5 years. With the decree of the President of 2015, she was transferred within her 5-year term to Haletsky District Court of the city of Lviv. The judge took oath of the judge in 2015. The term of office of the judge stopped on the 18th of October 2018 as her 5-year term expired. Today, Kateryna has the position of a judge in Haletsky District Court, but she does not administer justice because her term of office has expired. Basically, this is it. All the other issues can be discussed during our question and answer session. Robert, please, the word goes to you. Do you have any questions to Kateryna?
Yes, thank you. Good morning, Ms. Kotelva, and if you don't mind, I will say Kateryna. My name is Robert, and just to introduce to you, on my left hand is Norman Ash from Estonia. Next here is Gabriella from Lithuania. Then we have Jessica from Canada, and the right-hand corner is John from the US, and my name is Robert from the Netherlands. I would like to start the interview by asking you whether you can explain why you want to have the position in the High Anti-Corruption Court, and when answering this question, that you also consider whether you will be able to endure the stress and the pressure that may come with such a position.
Good morning, dear members of the High Qualification Commission.
And I would like to add, I forgot that, sorry to disturb you and to interrupt you, is that I would appreciate if you could answer within 3 minutes, because we have quite a few questions, and that would be helpful.
Yes, I understand. Once again, good morning, dear members of the High Qualification Commission of Judges of Ukraine, members of the Public Council of International Experts, all the participants, representatives of the public here. As to your first question, as to my motivation and my capabilities and whether I'm able to take this position. First of all, I have almost 25 years of general total experience in law. I used to work as an attorney, as a judge, and as a professor. I believe that my professional experience is sufficient, at least I would like to believe that it is so. My life experience is as well, in order to cope with this pressure and task. For me, working in this situation of even a excessive burden is normal. I like it when I have difficult missions and find answers to difficult questions. That's why I believe that I can be useful in this position, and I can be quite effective as well.
I will take you, there are some publications from you or about you in the press. And because of the positions that you seek in the High Anti-Corruption Court and the pressure that may go with it, I think I have to take you through those articles. I'm quite sure that you know to what kind of an article I refer. I asked my assistant to put on the screen a Facebook post from you so that the people can read what it says. And I will take you through some paragraphs of this article and would request you for a reaction. Well, I cannot read it, but what I believe it says, that this is a Facebook post and an article from the 24th of May 2020. And the article is called "Judge Seeks Help Because of Harassment. I Cannot Leave the House." And in this article, there's a quote from you, because I think you have written it yourself. In February 2016, after the trial on this case, I was blocked right in the courtroom by twin activists. They demanded that the 4 bandits be released from custody. You recall this, huh? Can you briefly tell me what happened here?
Yes, thank you. It was quite an old event. It's true that the development took place. I was really blocked. That was in 2016. It was not a usual event, although it was not unique for that period of time of Ukraine's history, because such situations happened relatively regularly. And I also provided references to other similar situations, and that happened in the case that I heard. To call things what they were, in fact, I was blocked, the prosecutor, and other participants. So as the situation was, it was a crime against the judiciary. And the problem was, the main problem was that nobody was punished for that. As regards my response for the High Council of Justice, I need to inform the High Council of Justice, the Prosecutor General, at that time, and that was February of 2016, that provision was not valid. The High Council of Justice did not exist at that time, it did not function, and the judges did not have a duty to report such events. At the same time, that case was investigated by the local law enforcement authorities. I was interrogated, other representatives of the court were also interviewed, but it didn't lead anywhere, so nobody was punished for that, in fact. I asked for recusal in that case, and the procedure is such that eventually other people, they heard my proposal for recusal, but they didn't find any grounds to grant it, and then I heard that case in complete compliance with the procedural law and with the substantive law. I made a fair judgment and decision that saw the Court of Appeals and the Supreme Court eventually, which in fact confirmed that I was able to work and to render fair and just decisions even in such situation. It was not just a pressure, it was a threat to my life and health. It was quite a dangerous situation.
Thank you. It must have been a terrible situation. But do I understand correctly that even though you call this a crime against the judiciary, that you didn't file, let's say, a notice to the HCJ or a criminal complaint against those individuals?
Dear Robert, let me underline once again, and please know, the High Council of Justice did not exist at that time, because as a course of the reform, that body was created to replace the previous High Council of Justice, and certain amendments were made to the law on the justice and the status of judges, which contained that obligation for a judge to turn to the law enforcement authorities. At that time, we didn't have that provision, but the law enforcement authorities, they have to respond to such situations, and they, on their own initiative, did that. And when a representative of the state, while performing professional duties, while administering justice, would be blocked, would be made a hostage, in fact, for 5 hours, the law enforcement system has to respond. That's why criminal case was initiated. I was interviewed in the course of that investigation, but it's an issue about how the state can respond to such cases. Why I refer to other situations? To show that at that period of time, and that was 2014, 2015, 16, before the High Council of Justice was set up, before the state bailiff service and state guard service was established. At that time, the government and the state was unable to resolve the problem, and I, in fact, faced it alone.
In this quote you're discussing, you say that the 4 people that it concerned are bandits. I would, but I don't know how it works here, of course, because I'm a foreigner. I would expect that the judge would say about someone who is subject to prosecution in a court case would be referred to as a defendant. Well, why did you use the word bandit?
Let me explain that. Now, as regards that publication, I learned about its existence as I was reading my own case file, my own judicial file. This is a Court UA publication. I do not read these publications because I wouldn't just read it. Court UA, its journalists never turned to me, and I never turned to them. I didn't provide my pictures. I didn't give them the right to publish my photos or pictures, and I have repeatedly discussed that problem because it has not been resolved. First of all, I believed that it was not correct. I would write my comments about such situations in special judicial web groups where I wanted to draw other people's attention to the problem, and of course it was painful for me as a human being, which I'm sure everyone can understand. So until 2020, I wrote such things. How did that Court UA use this information? Well, you would have to ask them because they never got in touch with me. They never received my official comments. Well, between judges, we can communicate, and while we discuss certain events, we can use some terminology, but it's not official, it's not formal. These are not official sources of information, and one cannot, and of course the judges should not allow themselves to use such words when speaking officially.
If I understood correctly, but maybe I'm wrong because I cannot read Ukrainian. My understanding was that what I mentioned is a Facebook post that was made by yourself, wasn't it? You wrote this text yourself, or is that not correct?
I did write a number of comments in the Facebook over several years, but this publication needs to be read and assessed. I'm not prepared to comment on it because I haven't worked with this publication and haven't approved the text, and I haven't given them my comments. This editorial never asked me questions. I had a number of publications in different judicial groups. This could be as separate posts, as comments.
Well, I have an extract from your Facebook posts, which I believe was written by you, where it mentions the word bandit. And as far as I can see, this was written by you and not by someone else. But maybe I'm wrong.
That may have been the case, and I may also be wrong. I cannot confirm or deny it at this point.
We do the next quote. And again, I cannot read this, but I believe it says, "It was Friday. The next court hearing was scheduled for Monday. Over the weekend, I started reading Social Network of Twins, and there were appeals to hang the donuts bitch, to come to the school, to the child, to find the parents, and everyone was urged to come to court on Monday to explain to the judge that heroes are not criminals. On Monday morning, I realized that no one is going to ensure order in court and my safety. I go to hospital and open sick leave." Yeah, when I read this and I think about you being a judge in the high anti-corruption court, if there is pressure on you, I would say that it is not the idea that you say, "I cannot deliver justice and I am ill," but that you stand up for your position. So please comment on this quote and explain to me that this will not happen when I'm your judge in the high anti-corruption court.
This quote is consistent with the circumstances, and as for the High Anti-Corruption Court, the security of the premises and the organization of the process where the judges have a state security service for cases like this was my reason to apply for the competition, and I stated it as one of the incentives for me to participate in this competition because I have been through the experience. It has definitely been a traumatic experience for me. I relived the experience. I am over it. I know it will not affect my ability to administer justice. It will not affect my fairness. I can leave personal offenses aside and impartially hear the case as consistent with the oath I've taken, as consistent with my duty. So I feel and I know that I'm capable of doing so, and this is not the pressure that can somehow break me.
Thank you for your answer. Maybe the next quote. Yeah? Yes? Well, it's a bit of a long quote. I will not completely cite it, but it says that at a certain moment you're suspended from the exercise of justice, and that is a disciplinary submission against you for dismissal from your position, and that you were left alone with the child in Lviv without a job. You are not able to return to Donetsk. It's disaster, you say. And of course, you're appealing against the decision. And then it says, and then Valentine shows up. The victim in the case I was locked up on. He is an employee of SBU K division. He says, "I'll save you." It was a miracle and a fairy tale. We develop a very warm relationship. We fight and win. VSP changes my disciplinary action from dismissal to a 6-month suspension and referral to a judicial school. Yeah. Again, I'm a foreigner. I have difficulties to grasp this, that some guy who is a defendant shows up. His name is Valentine. Allegedly, he is a member of the Secret Service, and then he helps you to change a dismissal into a 6-month suspension. Yeah, it feels to me very unjudge-like, these kind of happenings. but maybe you can respond on them.
Доволі важко це пояснити, бо
This is hard to explain.
я не пам'ятаю, щоб я таке
I
писала.
don't remember writing this.
Могли написати
The
свої
journalists
враження.
may have written their own interpretation. This text was written by a journalist. It wasn't me. As for the disciplinary proceedings, I'm sure there'll be questions about the disciplinary complaints against me. I have been through the legal review with disciplinary complaints. I've never sought any outside support. I complied with the general requirements, as I often always have done in my life, so I cannot comment on this. If I had then learned about the publication, I would have written a disclaimer or asked the editorial to withdraw the publication and responded in some way. Now, as I read it, perhaps not that carefully before this hearing, I too had many outstanding questions. Where is the information coming from? What are the sources of information for Sud UA publication, where they got the information from?
Well, I am told, and I've seen this, that this is again a quote from your own Facebook page. It's not written by someone else, it's written by you. And the only one, therefore, knowing what it means would be you.
Тоді я прошу показати і мені цю публікацію у Фейсбуці.
Could I then see this publication in Facebook that I had written then? Then I'll be in a better position to respond.
I asked my assistant to come forward with this Facebook page. And I wish to remind you, and I said this, that Facebook page is, the article is from 2020, and you refer back to something that happened in 2016. So apparently afterwards you're telling what's happened, which means that no doubt you have then again thought about what happened. You looked at your own Facebook page, and then the article appeared because it's a look back thing. Maria, can you please? You have the article in Ukrainian. Can you please show it? Just for her. One second. I hope it's okay, Mr. Chairman, that we show a Facebook page. Or
Немає заперечень.
I have no objections.
Ми всі зацікавлені.
We are all interested in establishing the truth, so let us examine the screenshots if they are available.
Вибачте, але це не мій допис.
Forgive me, but this is not my post. You're showing me the publication in Sud UA.
No, that's correct. But if you scroll down, there's a photo of a Facebook page. That's correct, Maria.
Я не підтверджую, що цей
I
допис був
cannot
взятий з
confirm
моєї Facebook
that this
сторінки,
is a
бо
post
на
from my
своїй
Facebook
Facebook-сторінці я
page
цього
because
точно не
I
писала це
definitely did not
100%.
write
Я
this
могла
on my
писати
Facebook page.
різні
I could have
публікації і
written
різні
different
свої
posts
думки в
and different
суддівських
ideas
групах або в
in the
коментарях.
judicial groups
Ця
or
публікація на
comments.
моїй
This
Facebook-сторінці
publication
не
on my
публікувалась.
Facebook page was never published.
Okay, thank you. I note that it is not your quote, for the record. I will just go on, and if it is not your quote, please say so, and please give us the explanation. Did you say something about this secret agent that was going to help you, and who is he?
В цих дисциплінарних провадженнях
In these
рятувала
disciplinary
себе
proceedings,
виключно я
I
сама,
was my
я
own
виїжджала на кожну
savior.
процедуру
I
в
arrived for
Вищу раду
every
правосуддя, я
procedure
пояснювала
at the
свої
High Council
дії,
of
я
Justice. I
пояснювала
accounted
свої
for my
процесуальні
action. I
рішення,
explained my
я
procedural
оскаржувала потім
decisions.
ці
I
рішення в
appealed the
дисциплінарної
decisions
палати в
with the
повному складі
disciplinary
Вищої ради
chamber in the
правосуддя,
full
потім в
composition
Верховному
of the
суді.
High Council
Я
of Justice,
рухалась
then in
виключно
the
законними
Supreme Court.
процедурами,
I used the legal
і
procedure
ніхто, жодна
exclusively,
людина
and no
в ці
one, not a
процеси не
single person,
втручалась.
intervened in these processes.
Okay, thank you. I will give you the next quote on the screen. What's the short quote? Okay. Is this the quote then I ask? Well, I will read you. Maybe this is not the correct quote, but I will read to you the quote I would like to discuss with you, which I was told is from your Facebook post, but where you say it may not be. It reads, then I asked my assistant to find out who is in charge and gave me my phone number. Sergi Bondar contacts me. He and I find common ground. I'm forced to compromise. I leave my sick leave, come to court, and change the measure of restraint for all four defendants to 24-hour house arrest. So I understand from the article that the four defendants are in custody, and that something happens, you're pressured, and that then you change this custody into 24-hour house arrest. Is this true? Did it happen? And can you explain this?
Дійсно, в процесі розгляду
Indeed,
цієї справи на час,
as
коли
I
вона
was hearing the case,
зайшла в моє
at
провадження,
the
всі
time
четверо
when I
обвинувачених
received
перебували
the
під
case, all the
вартою,
four
тобто
defendants
обраний
were
запобіжний
in
захід
custody.
тримання
They
під
were
вартою
placed in
десь
detention
півроку
through a court
розгляду.
decision, about
Та, напевно, це
6
було після
years of case
блокування.
review following the
Ще раз
blocking in the courtroom.
розглядалось клопотання в
Again,
межах
the
процесуального
motion
закону про
was
зміну
filed
запобіжного
under the
заходу.
procedural
Я
law for the
змінила
review of
запобіжний
the
захід
measure of
на
restraint, and I changed
цілодобовий
the
домашній
measure of
арешт.
restraint to
Всі
round-the-clock house
обвинувачені
arrest.
дотримувались
All the
цього
defendants had
запобіжного
complied
заходу, прибували
with the
вчасно на всі
measure of
судові
restraint and timely
засідання,
arrived for all the
що
court
і
hearings,
дозволило
which allowed
винести і розглянути в
us
строки цю
to
справу.
hear the case and resolve the case within the legal time limit.
The point is that within the scope of this article, the article suggests that the change from the position of the defendants being in court, being restrained and in jail, to 24-hour house arrest was the result of the pressure put by the people who are threatening you in court. That's the point. But of course, when you take a decision just changing a restraining order into house, fine. But the point that is made in this article, where you told me it's not your own writing, that comes from a Facebook page that shows your name, is that this was the result of pressure on you. And of course, the question is, first, whether this is true, and second, when you are a judge in the High Anti-Corruption Court, how you will deal with this. such issues? I mean,
I changed the measure of restraint because there was a justified motion submitted by the Defense Counsel of the defendants who had the grounds to change the measure of restraint. The case was on trial for an extensive period of time. There were legal grounds to change the measure of restraint, and I made the decision, a procedural decision to change the measure of restraint. You know, when it happened following the blocking, I can tell you on a humane level, it's hard, and it wouldn't be clever to insist that it was regardless of the pressure. But I tried to compose myself, try to abstract myself from the blocking. I could not procedurally leave the case. I had to proceed hearing the case. My self-recusal was not satisfied, and I had to work with myself extensively to retain my composure, to do my duty that the profession has laid upon me.
there's one last thing I will ask you about is, and that is this article from the newspaper is from 2020. The incident is from 2016. It was widely published, and the article in the newspaper shows, or alleges, possibly, that it is a quote from your own statement. Did you, let's say, act against this article, or did you go to court against it if it is not true what it said? Or did you do anything to make the public aware that what it says were not your words? Because it's all one big quote. It is between, let's say, how you call this? Quotation. It's in quotation. Because it seems strange. It's an old kind of thing. There is a Facebook post. There's an article 2020. If nothing happens, if you say it's not true what it says.
Indeed, the events happened in 2016. The verdict was pronounced in the summer of the year. It may have been 2016 or 2017. And then there must be some comments or posts that I had written in the judicial groups, not for the mass media. And both in 2017 and 2018 and perhaps 2019, it was a series, well, not quite a series. These were comments. I did raise the question. I wanted to draw attention to the issue from my professional community because what had happened wasn't okay. Can you imagine something like this happening in your country? This is not okay, and it shouldn't happen. It must not happen. I raised the issue at the National School of Judges when, as a student, I attended different trainings or workshops on integrity, professional ethics. I raised the question, what should I have done if I had filed for self-recusal? How could I continue hearing the case? I kept raising the question there and in my community, and it pained me on a human level because it's not okay. No one was punished. Perhaps you could advise me on the right way to conduct myself in this situation, because no one has given me the answer what would be the right way to handle the situation. It was beyond the professional ethics. It was beyond the human morale. It went that far. It was a very difficult situation, but thankfully it's over. So I could write a few posts, and then this publication put its own interpretation. I'm not entirely clear on what's written there. I saw the publication 4 or 5 days ago when I was given access to my judicial dossier, and I found the publication in the dossier. At that time, I didn't know it existed. It would seem to me that the journalist ethic dictates that they should have gotten in touch with me. It was 2020 when I was seconded to the National School of Judges, when I started teaching. My 2-year tenure was over, and I served my disciplinary sanction.
Well, of course, when I've read the story, I do understand you were in an awful position. I understand that. And I do understand you were pressured. And I have no idea what you should do in a position like this because I'm a foreigner. I would know what I would do in my own country, but that would be very different from what would happen here. And of course, I understand that that it causes some emotion. On the other hand, you will understand that the questions need to be asked if you apply for a court, which is well known that there is pressures from all sides, and also that even, let's say, free housing is presented because people are there subject to pressure. Being a judge, I'm told, in the High Anti-Corruption Court is not an easy job. There's one remark I would like to make. You didn't answer the question because the question was, you took this on 5 years later, it wasn't the press. Did you do something against it? And that was the question.
If I had known about that publication in 2020, I would have made a decision and then I could think about how to respond to it. But I learned about it only 5 days ago. Nobody ever informed me about that publication. Journalists never got in touch with me. Journalists, when they write an article, usually they ask judges for comments. The courts have press services, there are speaker judges in the courts, but how? When 5 years ago that happened, it's hard even to say why that publication was made in 2020. The judges of the central courts, and I'm also a judge of a central court of Lviv, which sometimes hears very glamorous cases, they're often subjected to all kind of information attacks, including media attacks. And I'm sure that the members of the High Qualification Commission of Judges, they know very well what media attacks upon judges are. And there is such a thing as information hygiene. If we were to read all these things, if we were to respond to every article, you wouldn't have enough time or nerves. That's why I comply with the principles of information hygiene. I wouldn't read very many media, and especially I wouldn't respond to them. If someone had sent that publication to me, or if the journalists had gotten in touch with me then, 5 years ago, I could have responded somehow. Now it's difficult for me to offer any comments because 5 years have passed.
Thank you, Kateryna. I think I've used my time more than I should have, and I'm always very strict on time. So I pass the floor to you. Sorry?
Can I, well, if Kateryna would like to add something, like a very brief comment.
I'm sorry. Sorry. Would you like something to add?
Yes, thank you. It's a very brief comment because I really did not answer your question. If at the High Anti-Corruption Court I feel pressure and things like that, will I be able to work there? You asked that question twice, in fact, and I believe that that situation, that story confirms that I am capable of doing that, because not every psychic is able to overcome such things, because it's a challenge for any human being. And I have strong nerves. I have a plastic nervous system, a quite well-balanced internal structure. I have built some internal defenses now against such situations, against media attacks. against all kinds of pressure. And I think that this experience is something that I can also use, because until you get into a situation like that, until you overcome it, then one could say that I am not subjected to, or I would not give in to pressure. But it's this kind of situation that tests a person about whether one can overcome pressure. To follow up on this subject for historic fairness, so that our international experts would understand the context in which all that happened, I want to say that it's true. In the history of this country, there was a period where law enforcement authorities, unfortunately, well, that's my personal opinion. I'm not talking for all of the commission. I'm also a judge who worked in those times and I know what happened then. The law enforcement system, unfortunately, moved away from providing protection to judges. And those persons who called themselves activists, for a certain period of time, they were outside the law, in fact, in the country, and they allowed themselves to come to the courts to undermine the hearings and to do such things as Kateryna has explained. They would bring, dustbins to the courthouses. They would take judges out of the courthouses and throw them into those garbage dams. And I agree with Kateryna. I am not aware of a single situation where anyone would be punished for such actions. So just for you to understand that such things really happen. What Kateryna should have done, I would like to ask her now. Many years have passed. I think you have reviewed that situation many times. What did you do wrong? What do you think? Well, 8 or 9 years have passed, but this situation, we're discussing it once again. Clearly, you did something wrong, the way I see it. If you think you did everything correctly, then please. I think that it was such a difficult life situation. I couldn't see a proper solution then, and I cannot see it now. I don't know how I should have, what I should have done correctly. I did everything I could in terms of asking for refusal and eventually bringing the case to completion, because it was difficult to continue hearing the case. I was true to my oath, to my obligation that I had taken up when I took that position. What I did wrong? Well, then somebody said that I went to a wrong courtroom because I should have gone to a courtroom that... No, I'm not talking about those trifles. One courtroom, no, about the essence, I don't know, Mr. Chumak, I cannot respond. I can speak about those little things like I should have gone to a room where there would be another back door or some things like that to save yourself. And I want to thank you for your comment about that historic period in the life of our country. It really happened, and I provided to the members of the Public Council a number of publications which described situations like those in different courts. And it was not when they only blocked the judges. They would destroy the doors in the courthouses. They would destroy, smash the furniture in the courthouses. That's what happened. Fine. Then let me ask you differently. What conclusions did you make after that situation? What if it happens again tomorrow, God forbid, in the High Anti-Corruption Court, another rally, and again, people carrying all kinds of posters, threats to you? Well, it was not a simple rally, because rallies took place and they are taking place now, and even at the High Anti-Corruption Court, colleagues who work there, they know what it is, and media attacks. That was really a situation which was very intense. You cannot compare it to a simple rally or simple media attacks. What conclusions did I make? Well, I decided that, thank God, my country left that period. Thank God the High Council of Justice was made, and the Judicial Security Service is there now. It is working. The High Council of Justice responds to such situations and turns to the Prosecutor General's office. And today it is effective because such situations do not take place today. That only happened in the period between 2014 and 2017. After the High Council of Justice started functioning, at least I'm not aware of any situation like that. Fine, Katerina, let's proceed to another situation, although it is related to the previous one. That's about your disciplinary proceedings and a case against you and your disciplinary sanctions. There, the situation is quite well known. You resolved a case. You made a decision which was eventually quashed by the Court of Appeals after an appeal was submitted by a person whom you had not held liable or who did not engage as a participant of the process, but you made a decision about that person's rights and duties. That's what the Court of Appeals said and quashed your decision for those grounds. How can you comment your actions? Because that was quite a gross violation of the procedural law where you decide a case in the absence of a person whose interests are a part of that case and the claim or the lawsuit. How can you explain why did you not engage that person as a party to the trial? It's true that there was such a disciplinary case against me. Here I'd like to note three issues. First of all, it was the first ever disciplinary case in my professional career. Neither as a lawyer, an attorney, or as a judge, I had never been held liable for disciplinary breaches. That was just once. Why did that happen? The case that I considered was about considering or approving the right of ownership to certain entities and lifting the arrest for certain types of property. Where was that arrest imposed? It had been imposed in another case on a claim of that person whom I did not engage in the trial as part of a civil case on recovering debt. One citizen tried to recover debt from another citizen, another person. That case had been going on for almost for more than 2 years. There was no decision in the case. It just some property had been arrested or seized. Incidentally, yesterday I looked it up at the register. I looked at what happened to that case. 11 years have passed. It has not been resolved. The arrests are still there, and there have been 58 procedural documents. People still keep trying to have those arrests lifted, and they cannot do it. So the case does not go on, and the assets that have been seized include vehicles, corporate rights, and even vehicles. While I've been thinking about that for 11 years, the person cannot be using one's car. Well, I'm not a driver, but I think that that car has lost a lot of its value after 11 years. And after 11 years, that civil case, was a case where the plaintiff could not prove that that existed, and only those, a lot of property was seized or frozen. And then I looked into the essence of the situation. It's a kind of an eternal question. What kind of decision should it be? A legal one or a fair one? What is more important, the essence or the form? I looked into the essence. and I breached the form. It's true that I violated the procedural rules. I thought I was protecting the owners. That's the right of ownership. That's the right to peaceful ownership of one's own property. And those facts, well, I cannot assess this case that has been in the first instance courts for 11 years, but these facts are still there. And as a result of my trying to balance up the essence and the form, I didn't find the right balance. I made a procedural mistake as a result of which I was held liable in terms of disciplinary proceedings. Yes, you were dismissed, in fact, and you were sent to to get a training, special training. Let me tell the experts about what the end of the disciplinary proceedings were. You took a special training, and then you took a qualification test at the High Qualification Commission of Justice of Ukraine, and you were considered as such that you can deliver justice in your own court. Yes, absolutely right. I took that special training, and in fact, that I had started it before the disciplinary proceedings and then during it. And then what happened after that, I took that special training course. I confirmed that I was capable of delivering justice in my court. In fact, it was my qualification test. It was a completely similar procedure. Then I took a number of additional training courses. Fine. Okay, let's be brief to answer clearly with our questions because we don't have much time. Look, but do I understand correctly that it was that disciplinary case and those sanctions against you, the need to undertake those trainings have led to the situation, but for 6 years you have not had that proper authority to administer justice? Well, I wouldn't say that. Primarily it was related to the fact that the commission didn't function at that time. Now I'm taking up all those procedures, and you know very well that I always come whenever I'm summoned, if I have to come to take any tests or any competitions. Well, that's the only reason was that the commission didn't function at that time. Okay, what conclusions did you make after that situation? So you looked up for a balance between legality and justice or fairness. So the logical question is, then you decided in favor of justice, and in a way you sacrificed the law. What conclusions have you made from that case and the disciplinary case against you and the sanctions against you, and as to what happened to you in those disciplinary proceedings? And what do you think about your actions now? What kind of balance would you choose today? Today, I would favor the law because it's an issue about the proper legal procedure, and a proper legal procedure for a professional legal expert should come first. It's like the form and the essence. The essence cannot exist without the form. As I did not comply with the form, I didn't help anyone, I didn't protect the rights, and only created problems for myself because I did not comply with the form requirements. And that's why my conclusion is that the formal procedures are to be complied with. All right, thank you. Then I will proceed to the next question. Well, once again, it would be related to your professional ethics. That's again a Facebook post. I've read it myself. So here you wouldn't be able to say that you did not write it. That was May of 2023. Again, another well-known situation. You're quite a well-known person in the country. You're active, you provide comments to events, you're not afraid of expressing your opinions, and I like that. However, there are some professional ethical issues, and I would like to discuss your position. It's an issue about election of the president of the court in your court. At that time, you didn't have the authority to work as a judge, and I understand you did not have very simple relations within your workforce, and you thought that some parts of your colleagues blocked the election of the president of the court. That's what you said. In that case, you wrote, and again, that was your post that was disseminated by the media later, and that situation became quite well known in the country. And again, it brought to more tension within your team in your Haletsky district court of the city of Lviv. Can you comment upon that situation? Tell us about what forced you to write about internal events in the court for all of the countries so that the country would discuss it.
Дякую. Значить, ну,
Ви зрозуміли ситуацію.
Ну я
Did you
одразу
understand the
хочу сказати,
situation?
перше відреагувати щодо непростих
Firstly, I would like
стосунків в
to
колективі.
respond
В
about
мене
the
нормальні
complicated
робочі
relations in the
стосунки в
team, and
колективі. В
I
мене
would say
немає
I have
конфліктів
normal
в
working
колективі. Це
relations. I
звичайна,
don't have any
я
conflicts.
вважаю, це робота.
It's all
Значить,
about
що
work.
стосується цих постів стосовно вибору голови
As for
суду.
the post about the election of the
В,
president of the court,
також в Україні в
again,
даний
in
історичний
Ukraine,
період
in this historic
існує
period,
проблема
there
вічних
is a
голів
problem
судів. Ну, вічних
of
це в кавичках. Це голови
perennial,
судів,
in
які
brackets, presidents
займають
of the
свої
court. These
посади
are the
навіть
presidents of
не
the
декілька
court
років поспіль,
that
а
stay
десятки
on this
років
position
поспіль.
for
Всім
years
відомо,
or
що
rather decades. It's
це
commonly known
демократичні засади,
that
яким цей був напрацьований запобіжник проти свавілля,
there
що
is a
голова суду або
democratic
там певна посада, вона
requirement
має
that put
змінюватися.
in a
У нас
safeguard
виходить,
that
що ці
people should
посади, і
change
це
on
теж
the
це не
position
тільки
such as the
притаманна моєму
president of the
суді, ця
court.
проблема.
And this
Це в
problem is not
Україні низка
inherent
судів,
in my
які
court,
мають
but there are a
проблему.
number
І
of
до
courts
неї
in
було
Ukraine with the
потрібно
same
привертати
problem. And
увагу.
this
Це
problem
не ок.
needed
І
to
плюс
be
це
raised because
прописано в
it's not
законі, що
okay.
голова
And
суду не
there's a
може
legal
обиратися
requirement that the
двічі
president of the court
поспіль на цю
cannot be
посаду.
elected twice to the same
Більше,
position.
ніж,
More,
перепрошую,
I'm
тричі не
sorry,
може. Двічі може, тричі
thrice.
вже не
So he
може.
can be elected twice, but not
М,
3 times.
В нашому суді голова
In our
суду
court, the president of the court
ну, більше 10 років точно
has
вона
been on
перебуває
this
на цій
position for 10
посаді.
years for
Я
sure.
висловлювала свою думку, те, що я
I
зараз говорю, я те,
spoke
те
my
саме говорила під час
mind
зборів суддів, я
and I
виступала там,
spoke my
я говорила,
opinion
що це
during the
ненормально,
assembly of
щось треба
judges saying that
якимось
this is
чином
not
змінювати.
okay. We need to change the
Оскільки це не дало
situation.
результатів,
This
і
wasn't
голова
effective,
суду, вона і
and the
сьогодні
president
залишилась
of
на
the
цій
court is
посаді,
still
то це
remaining on
пряме
her
порушення
position. And
закону.
this is a
В
direct
законі
violation
написано не
of the law.
можна,
The law provides a prohibition
Получається,
of
що суддівський
tenure,
колектив сам
but
породив
the
це порушення.
judges
Я вважаю,
are
що це,
initiating a
це
violation.
неприпустимо, і на це
I
треба
feel
було
it is
реагувати.
inadmissible,
Яким
and I felt I
способом я
had to
відреагувала? Я
respond.
написала
My
Вищу
way
раду
of
правосуддя
responding was
скаргу, я
writing to the High
написала
Council of
в Раду
Justice, filing
суддів
a
скаргу.
complaint.
Рада
I
суддів
wrote
мені взагалі не
a
відповіла на моє
statement to the
звернення,
Council
нічого
of
не
Judges. I
відповіла.
never got any
Вища рада
answer from the
правосуддя, але я
Council of
ще одну
Justice.
скаргу написала. Там вже дві
Same for
скарги,
the High Council
виходить.
of Justice, but
В
I filed
першому
another complaint. So there are
випадку
two complaints to the High
не
Council of
знайшли там
Justice.
порушення,
First time they
відмовили
did
мені
not
або
find a
повернули скаргу, я не
violation,
пам'ятаю, тобто воно
or they just
безрезультатно було.
returned my
І тому
complaint,
я
so it
вирішила
was in vain.
застосувати оцей канал, те, що
Therefore, I
називають
decided to
зовнішньої
use
комунікації, для того,
external
щоб привернути
communication
увагу до
channel
цієї
to
проблеми.
attract
Але
the
мені тоді
attention to the
віддзвонили і
problem.
писали,
At
я
that,
активний член суддівської
people
спільноти,
would
я
call and write to me,
спілкуюсь з
and
суддями по
an
всій
active
Україні.
member of
Мені
the
тоді
judiciary
дзвонили і
community,
писали, що
and
в
I
нашому суді
know
то й те
people
саме, і це
from
все
all over the country,
нестерпно,
and
і з
people
тим
would
треба
write and
щось
say, we have the
зробити.
same in our
І от
court,
тому
it's insufferable,
я
we need to
привертала
do
до цього
something
увагу.
about it. So I raised the question.
Зараз вважаєте, що
And you feel now
Абсолютно.
that you did the right thing.
Абсолютно правильно. І я
Absolutely,
вважаю, що я
absolutely.
хочу,
It was the right
щоб
thing.
ми прийшли до того,
I
щоб
want us
такі ситуації не
to
мали місця, тому що
be in a place where
кожен суддя
such
реагував би на
situations would
них.
not happen, when every
правильно я
judge
тоді
would respond.
розумію
Do you
історичний контекст,
understand
що
the
ця голова
historic
суду двічі
context
була
correctly, that this president
обрана вже
was
головою,
elected
закінчився до
twice as a
листопада, і
president,
її
and
голова
when the second
колектив
tenure
більшість обрала її
expired, the
заступником,
majority
і вони судячи з
elected
вашого
her
допису
as the
блокували
deputy,
обрання
and they
голови для
blocked
того, щоб
the
ця
election
особа
of the
дорученим заступником
president. So
виконувала
this
обов'язки
a
голови, а
person
голови
acting
тут
as
не було.
the
Ну, тобто
deputy
обирати
would
іншого голову.
act in the capacity of the
Абсолютно.
president. So there would
Абсолютно.
be no
Тобто
president in
голову
the
не
court.
обрали, обрали
Absolutely, the
заступника, і
president
людина
was not
залишилась в своєму
elected, only
кабінеті.
the
Ми ж
deputy
маємо
president was
точно
elected, and she
дивитись
stayed in
суть,
her
що
own
мають
room. We
змінюватись
need to look
посади,
at the
має
fact that
змінюватись
the
влада,
position
бачите,
needs
чого не
to
змінилось, всі
rotate, the power
залишилися
needs
на
to
своєму
rotate,
місці при
but
тих самих
nothing changed
повноважень,
there.
просто
People
була
stayed
голова
with
суду,
this
стала
person, stayed with the same
виконуючи
powers, but
обов'язки
she
голови суду.
became
А
acting
потім знову вже
president.
переобрана на
And
голову
again, she
суду,
was
навіть
re-elected
не
as the
перервалась
president.
ця, якби хоча б на один
So
день когось
there
іншого
was
обрали,
not
розумієте, можна
even
було
a
говорити,
chance for
що
someone for a
вона не
day
поспіль
then she wouldn't have had continuous tenure in this position, but it was continuous, and I feel it constitutes a violation. I don't know how the High Council of Justice will rule on it, but I think it's a flagrant violation, and I decided to respond. It is clear. If I may ask you a property-related question, and it pertains to you from 2015 being a judge in the Halitsky District Court of Lviv, but in your annual declarations for 20 and 21, you have stated the only place of residence, the city of Kiev, and you have not stated any property that you would use in Lviv. So, in fact, in the years 2020, 21, you did not reside in Lviv, or didn't you turn up for work? So, if you would please explain why in 2021 you did not declare any assets in Lviv, even though you're a judge of the Halitsky District Court in Lviv, even though you don't have the authority of the judge, you should still turn up for work and be in Lviv and live in Lviv and not in Kiev. This is perfectly right. In summer 2020, I was seconded to the National School of Judges. This is when my disciplinary sanction was completed, because the National School of Judges cannot take on people to teach who had a disciplinary sanction that hasn't been served. So I was seconded to the National School of Judges, and I am with the Department of the Training Judge, and my workplace is in Kiev now. In this connection, I relocated to Kiev. My child is now studying in Kiev, gymnasium for 2 years. I rented an apartment in Kiev and stopped leasing an apartment in Lviv. And for 2 years, I've been living in Kiev. And this is connected with your secondment to the National School of Judges for the period. Absolutely, there's no other reason. Thank you. I have no further question. If you have any, please go ahead. Kateryna, I have a few questions I would like to address you. I am a member of the Commission Sabotage. The first question pertains to Article 10 of the Convention and the duty of the judge. By this, I mean the freedom of expression of opinion and the duty of the judge to maintain loyalty with the judiciary if it cannot be resolved in any other fashion, or the threat of non-disclosure of information supersedes the good standing of justice. So where does this line lie between the citizen's right to the freedom of expression and the duty vested in a judge by the Code of Professional Ethics and the law? Your question is clear. I did examine the question in the light that I do practice exercising my freedom of expression professionally as well. The limit is about every particular situation. On the one hand, the authority of justice, and on the other hand, the significance of the matter raised, the significance, the gravity of the matter. The questions that I had raised had the significance. I've always tried to do in a reserved and moderate fashion, not to infringe on the standing of the judiciary. And I wasn't disciplined, I wasn't reproached. If you had looked into the matter, there's a case law on the public servants, but I believe it could also be applicable to a judge. So did you take any action to regulate the matter before going into the public? So immediately you went to the media, you went into the public domain. I have always been well balanced when making my decisions. I know the case law, Kudeshkin versus Russia, Baka versus Hungary of the European Court of Human Rights. I looked at the case law, I studied it, I know it well. And in the principle of the loyalty principle, did you take the steps to regulate the situation independently before going into the public domain, independently regulating
Яким чином?
How? That is also an answer. Thank you. And another question, which was raised by the civil society organizations in their submissions to the Commission, and it is to do with an interview that you had given about your trip to the Nepal. I understand that it did happen in 2017. Yes, absolutely. I read the explanations, and the estimate is correct, roughly, but it's the cost of the tour, excluding the flight. No, it was hike. So the flight, it was about $2,300 they estimated, and this is roughly what I spent on the trip. This is the cost of the tour, and it included the flight. It did include the flight. The state border guards saying this is you leaving Dubai. You flew via Dubai for 22 days. Yes, it was a long flight via Dubai. So the cost of the tickets is more or less that. What about the other expenses? You must have had guides. It's an organized tour, some food, some lodging. I can explain. I bought the tickets in December 2016, and I had planned that I would fly in April 2017. About $1,000 was the worth of the tour of the organizers. It was a backpacking hike. It was a trekking. It included the lodging. We stayed at some lodges overnight. The tickets were not included. Some passes. So it was that price plus tickets and accommodation, but the prices are very low in Nepal. So maybe 1,000 for the tickets, maybe 1,500. So the question is about your income, because the civil society organizations wanted us to pose the question where these expenses consistent with your income. They were fully consistent. I provided my credit details. I had to take a loan that I had declared. It's a credit card of interest-free overdraft, and I would tap into the card and repay it. Then I had little savings, some savings that were sufficient to cover the return, to cover my living if I ran short of salary, but I did not have to declare them. They were below 50 subsistence minimum. This is my money, but they were recycled from one card to another, and the cash that I had at hand. Thank you for the explanation. Any further questions? Ruslan, over to you. Good day. Thank you for the opportunity to ask the question. I'm Ruslan Melnik. Kateryna, I have two questions from what I've heard today. The first is about the publication in the judicial publication that we've dedicated a lot of time to in this interview, where you denied that the screenshots allegedly from your social networks presented there are accurate, and you didn't know about the publication, and you refuted being the author of the publication of the post. So would you like to defend your reputation? Do you have an opinion? Are you going to sue for libel and your business reputation with the publication? If indeed the publication had falsified the information, in fact, they deliberately discredited yourself as a judge. So what's your opinion? Do you feel that the journalists have the right of their interpretation and can do things like that? I'll give it thought. When I first read the publication, my first initial thought, what are the sources? Who gave my personal photographs? Who gave the permission to publish my personal data? I did not give the permission. So my first initial response was to refute. I even thought I should write to the publication before the interview. So is it some personal data or is it not true about yourself and it's a complete falsification? I wouldn't say it's a full falsification. The article does contain some of my statements, but their interpretation, the presentation, the way they were put together into the product, the title of the product and the presentation, all that deserves thought and I should think of the right way to respond, so I'll do that. It is clear. And the next question then. Firstly, I want to remark and thank you for being so open. I looked at your page in the Facebook. It's open, so anyone can access the page. It's a page that has updated information. You are active publicly and you post awareness raising posts, you give your opinions of some current events. So I would like to go back to the post that he had mentioned. That is to do with commenting on the developments in your courthouse. Again, this publication is open for review for the public. It's the 25th of May, 2023. And let me quote your writing. As a person, I'm deeply impressed by the flagrant violations of my rights by the person who is performing as the president of the court and the tolerance on the part of other judges of the same court. But I'm a judge first and foremost, and I feel it's my ethical and professional duty to respond to the arbitrary organization of the workings of the Halitsky District Court of the city of Lviv. In the context of the Code of Judicial Ethics, in particular, Article 20, which states that the participation of the judge in internet social network is acceptable, but the judge can only comment on the information that would not damage the standing of the judiciary. It was reworded several times, but the intent is the same. So do you feel, as a judge, you can segregate being a judge and being a person, and on the one hand, give a comment as a person, as an outside observer, as a member of the public, and at the same time as a judge, and the action of the judges you describe in a negative light. Does it violate the provisions of the Code of Judicial Ethics? This is a very good question. Any judge, any public servant is still a person. Moreover, there's a demand of the society to see a judge with a human face. I read the social networks of the judges of the Supreme Court, and I like it when I see a human face on a judge. And I always say that if my case is heard, I would like this case to be heard by the judge who is seen in the social network, who I can read about to see what kind of person they are. It must be very difficult to segregate because people are people and judges are judges. And this integrity of being humane and being professional intrinsically interwoven, it's something that every judge should strive for. In these comments, you don't think they violate the Code of Professional Ethics, and you don't think you're damaging the standing of the court and the judiciary. specifically with these comments, and as I said so, I waited up. I did not write the post emotionally. I try to present the facts in an unbiased manner, just to record that these developments are happening. I did so deliberately, consciously, and if I had felt it was a violation of the professional ethics, I would certainly have not done so. Thank you. Ruslan Sidorovich, a member of the Commission. I will have a few questions I would like to pose to you. One, I believe we haven't finished the question posed by Roman Subadash about your trip. So tell me, Nepal are high mountains, the highest mountains. So you are into hiking? Is that so?
It was my first ever trip like that, and I went to Nepal at once. It was a very interesting experience. I left my comfort zone, and I believe that, whenever I have some problems or complications, I always remember how I walked up the mountains there, trying to overcome my physical burdens, and it gives me strength in other areas. That's why I advise everyone to go to the mountains. Well, I have some friends who are alpinists. I'm not an alpinist myself, but I have some remote idea about the fact that it's not very simple. Tell me, how high did you come? Well, I took that track, the Annapurna track, and the Tornala Pass overpass. I think it was 5,200 meters. I think that after 3,000 meters, this mountain disease starts. And in fact, I had it for several days. It was quite an interesting experience. And when I was there, I didn't like it, of course. But then when you start reviewing and reliving it, when you come back, you understand that there had been nothing better in your life. Well, yes, I can believe in that, but how many persons were there in your group? It was a small group, 5 or 6 persons. And there were 2 organizers and probably 6 participants, up to 10 persons all in all. And did you have any Sherpas in the group? No, we didn't have any Sherpas. I carried my backpack myself. No, you didn't take any Sherpas. No, we didn't have any oxen that one could use. We just walked. So thank you. Enough to Nepal, a wonderful country. I've never been there, but maybe one day I will. And it's an interesting story. Kateryna, I have several questions related to your disciplinary case and that story. You remembered at the very beginning. You understand very well that there would be questions about that to you. Quite an interesting story it was, what my colleague Serhiy Chumak asked you, putting so many questions to you, especially in view of where you want to work, where you would need to keep up those balances. What does it mean for you, and in terms of legal regulations, the legal framework of Ukraine and European standards? What is rule of law for you? What does it consist of? Rule of law. Well, when I studied at the university, we read that there are 2 categories: the rule of legal regulation and the rule of law. And we said, when we correlated those 2 things, that when you only use the law can be, or legislation can be fair or broader, while law includes more principles, more traditions. So the sources of law are not all the legal acts, but all the other things that are in the theory of sources. And that's how I based my understanding for a long time about what the rule of law was. And then I took a number of courses, including the ones run by European projects, and there they contain several criteria for identifying to see whether the rule of law is complied with in a certain country. And for example, there one could find statistics of judgments and how human rights are respected in a country. So such kind of external criteria that one can take into account to say whether the rule of law exists or not. But human rights is my favorite subject. Well, we're not going to discuss human rights now. I thought that you would remember the checklist adopted by the Venice Commission about whether the rule of law is respected or not. Well, can you give me 3 or 4 or 5 elements of the rule of law? Strange as it may be, but first of all, that's legality. In any case, that's a criterion of the rule of law. And this is what I studied back at the university. What formed me as a legal expert was quite a primitive understanding of original legality, human rights, non-discrimination, equality. Is there justice there or fairness? Well, justice is more a philosophical category, as they say that one has one's own justice, and this is probably true. And if a judge thinks first and foremost about one's own understanding of justice, it can become biased, and that line is very dangerous. I would like just to understand your understanding of it. Fine. As you have remembered yourself that legality is there, and the Venice Commission has been saying that since 2011, that it's an element of the rule of law, from the point of view of law and legality or lawfulness. According to the Code of Civil Procedures and the position of the Supreme Court, you are a professor at the National School of Judges within the context of your disciplinary case. If whose duty is it to identify the proper defendant in a civil case? Well, it's the plaintiff who identifies the defendant when one sues a person. So it's the plaintiff who decides against whom the claim is. What if one has not done it, or if one has made a mistake? Well, then the authority of the judge is quite restricted, even within the context of engaging a third party on one's own initiative. The judge can do that, but it should be very careful. If, for example, these are some, for example, services for children, then the judge is to engage a representative of such a service. But if it's, for example, the issue of how to identify possible parties, then it's still the plaintiff who is to decide who is going to be defendant in one's case. Well, Kateryna, I think that we do not have a discussion. The judge should always be very careful in any situation. But as to whose duty it is to identify the defendant, the Supreme Court said that if the plaintiff makes a mistake while identifying the defendant, then it's the duty of the judge. If a plaintiff, for example, sues a wrong defendant, the judge would have to engage the right defendant, and he would turn down a request against a wrong defendant. Is it a civil process? Well, perhaps administrative? No, it's a civil process. Thank you. Dear members of the Public Council of International Experts, maybe you have a desire to ask any more questions?
Yes, Mr. Chairman, I have 2 follow-up questions, short. I will ask my assistant to put up the Facebook post where we make a picture of, and I just want to ask the candidate to have a look and answer, is this your post or is this not your post? Is this the post that you wrote, or is this fake? So maybe you can have a look, because I understood you say that this is fake. But Yes or no? Huh? It's either fake or it's yours.
Той пост – це не весь текст, який
Well,
мені
this is not
показувала
all
ваша
of the
феміністична
text that your
комп'ютері, там
assistant showed me
довгий
in her computer. That was a
Його
longer
треба
piece of
читати
text.
повністю
That's why I need to
уважно,
read it
якісь
and read
частини
it carefully.
Please go ahead. There's a longer text from a newspaper article, and in the article there's a photograph of this post. What I understood is that you say that this is not your post. Please have a look. Is this your post or is this not your post?
Пані Катерина, ви можете отут ближче, якщо є.
Та я
Ви бачите?
Ну,
Далеко просто.
тим більше я знайомилась з матеріалами, я дивилась. Я
She
думаю, що це
says, I've read it. I think that is a compilation from different comments that I made. It was a long time ago. It's difficult for me to say that it was not a post on my Facebook. I cannot say it for sure.
Do you say that they made a picture of something that was not written by you?
Може бути, звісно.
Of
Чому
course, it
я
is
хочу
possible.
подивитися, де це
That's
написано.
why I would like to
Щоб
see
я хотіла
where it
спитати
was
у
published. I
журналістів.
would like to ask the
Because what they did in the article is that they quoted you and they wrote down the text. And in the article, there's a photograph of a post which bears your name. And if you read the post and you read the rest of the article, they match. So have a look, is this your post or is it not your post? It cannot be so difficult because I didn't write it. You did write it or you did not write it.
Шановний пане Роберте, я
Dear
читала цей
Robert,
пост,
I've
цю
read
статтю
that
перед
post and I've read that article before the interview because it's a part of my file.
Цей пост в тому
This
вигляді,
post
в якому
in its
він
present
тут
form,
опублікований,
in the
я
form that is
написала.
published here, I did not write it.
Picture which is part of this article, you see it on the screen. It contains your name. It contains a time. It contains text below it. Did you write this part of what you see here on the screen? Did you write this?
Ну, це скріншот.
It's a screenshot. Where was that screenshot taken from? If you use any social media and if you enter my name or the name of any other person, you would see a number of different pages. That's why it is difficult for me to say, because it is true that there are some facts that are real, but in this form, in exactly this form, no, I did not write that post. This is not mine.
We have noted that this is not your post. Is that correct?
Так. Так, там написані
Yes.
такі кричущі
In
речі,
fact,
чому
it
не
has a
відреагували на
couple
це,
of such things,
судові
like
органи?
why
Чому
did not
одне
the
село
judicial bodies
видання,
react to
суд
it?
UA,
Why there's only one
опублікувала цей пост
publication,
і не
media
зв'язавши з суддею?
court
Чому
UA
іншої реакції
published it, why there was
офіційних
no
органів,
other
від
publications and no response
судової
from
влади,
the
від
official
прес-служби
authorities, from
суду,
the judicial
не було
bodies,
цього
from the
приводу?
court service? Why there was no other publications? Why that was the only one?
Well, that's exactly what I find so strange. I've been in the media in the Netherlands many, many times. I can tell you when that happened, I would have many comments from everyone. It would be Facebook all over, and everyone would know that there would be an article about me because that's what it happens. And I know, of course, the newspaper who writes this. I read this quite often because I want to know how it works in the Ukrainian judiciary. And I would be quite sure that if there would be something like me in a newspaper like this in the Netherlands, that my colleagues would contact me and say, hey, Robert, you're there. And they say awful things about you. Can you say, can you respond? But you say that no one in your environment, no judges, no one told you about this post. I find that quite strange because my short experience in Ukraine makes clear that everyone knows everybody and always reads Facebook, especially about themselves. So it's you understand that I find it strange that you say that no one ever pointed out this article to you.
Я абсолютно поділяю ваше
I
здивування.
absolutely share your surprise.
Якимось чином треба на це
And in some way, one should respond to that because I'm an active member of the community. I'm often interviewed. I can write things in Facebook. People write to me in Facebook. It's hard for me to say what happened 5 years ago and what was the purpose for that article to be published
цим виданням.
by that
I
media.
have no further questions. I look at my colleague. No, thank you. Back to Mr. Chairman.
Дякую.
Thank you very much.
Є питання, да, Сергій?
A question?
У мене є
Sergey, you have a
питання.
question? Yes, I have a question. Kateryna, I just entered your Facebook page. Your name is now in Cyrillics there, while in this post, that's in Latin characters. Do you have two different pages in Facebook? No, I have only my own page where everything I write is in Cyrillics, including my name. Well, probably one can change the name in the process of publishing. At that time, did you have a page in Latin characters or in Cyrillics?
Сторінка моя завжди була
My
написана
page has
українською.
always been in Cyrillics. In other words, you've never used your name to write
Я
it
не
in
пам'ятаю,
Latin
взагалі,
characters.
якийсь період часу взагалі не була
For a certain
користувачем
period of
соціальних
time, I
мереж.
did not even use any social media. Well, in 2015, 2016, yes. In 2015, yes. But that was 2020. Unfortunately, there is no information here about when was your page closed and since when you've been using that page. Unfortunately, I cannot see this information.
Одне єдине видання
Just one
має
media
таку публікацію. Тобто,
that published
це така,
that article.
доволі
This is quite, some blatant things are written there. Nobody reposted it there. That's strange. Well, it's not my question. I believe that there is no offense here. You didn't, there's no crime here. It's just an issue of honesty. Because in this post, it's true that one can read about the circumstances of your life, the case, disciplinary case, Halitsky District Court. Who would need that? Who may have needed, publish this as a fake, as Robert suggested, so that I understand all of that happened in 2016 and the publication was made in 2020, 4 years later. Why would anyone want to go back into history to thwart something, to create some fake pages, to fake that post, perhaps? Wouldn't you think that I understand that one can read certain things there that can be interpreted in a different way. And at the end, it says that you find yourself in a very difficult psychological state because of those events. But everything can be explained. Just a lie cannot be explained. I'm sorry. That's what I'm talking about. That's why I would propose that you look at this thing and because you said that a part of the post is what you may have written, perhaps some comments, but in general, you did not write it. Then tell us which part of that was the one that you wrote and which was that you did not write. Or maybe try to remember. I understand that 10 years have passed. Maybe you wrote it anyway, and maybe then you can explain certain things to us. Because I see that the international experts, and Robert in particular, they are still have some kind of mistrust about the fact that you didn't write that. It's a screenshot that was made 43 minutes after that post was made. It's difficult for me to imagine that somebody has created a fake page for a Halitsky district court. They called it Kateryna Kotelva wrote that huge post in Russian to somehow discriminate against you, to give you some negative reputation or things like that. Please. Thank you. Well, as regards that particular post, I cannot either confirm or deny it, because I did write many posts, maybe a dozen, well, not posts, these were comments. Once again, I didn't write it in my own page that I had, my own page. I could have written that in a chat group with the judges, and that perhaps would have been a dozen or 2 dozen comments where I described those events, because if one reads it, the main facts are correct. And I have confirmed in this meeting that this had really happened and that this is a part of my past life. Some of those facts, well, I don't really understand them. I don't remember, at least having written that. I cannot say that I remember that. Which facts out of this post are not true? Let's put it this way. Which facts? You said you first saw it 5 days ago, so you remember it now very well. If you don't, you can come up and have a look. Which facts are not true mentioned here? Well, I've already been asked about, for example, an SBU, State Security Service officer. He definitely did not interfere in my disciplinary case, that's for sure. This is not true. If we look at the post, then you don't write there that he interfered. It says that he started helping you to bring back justice, and then a miracle happened. The HCJ changed its decision. It didn't say here that this Valentine influenced the High Council of Justice, but it just says that he helped you and a miracle happened. That's what it says, in fact, and the HCJ changed its disciplinary sanction against you and decided not to dismiss you and sent you instead to the National School of Judges to Ukraine for a training and a qualification assessment at the High Qualification Commission of Ukraine, so you could confirm your ability to deliver justice at the first instance court.
This is a kind of penalty there is in Ukraine. So I didn't see the SBU officer interfering. This, my understanding may not have been right. It's been many years since. For many years, I haven't been using Russian language, especially in public space. It was written a very long time ago. I've long transitioned into the Ukrainian language, so definitely it's some very, very old post. With the course of time, people may forget. I've written a lot of emotional posts to do with this topic because it hurt me, because it worried me, and I had to relive the experience and put it behind. And it's no longer an emotional trigger for me. So I could have written something, I may have forgotten something, so you allege you may have written it. I do assume, but did not write it for a newspaper. I wrote it in a group for judges. There's no post on your Facebook. No, it was never on my Facebook. I could have written it in a page. In groups, we write posts, comment on events. It wasn't written on my page. It wasn't an official appeal. Why are you so afraid of the post? Why are you afraid of admitting that you had written it? What scares you so much? I don't want to take the responsibility for something I haven't written. I don't trust this publication. Robert put it well, that this publication did a photograph, a screenshot, and then had cited several quotes from the Post. The publication, despite its reputation in your eyes, which isn't a very positive one, simply went down your post and added little interpretation. They did disseminate it all over the country. At the time, the post may have been blocked or deleted, etc., but it was made 43 minutes after posting. You may have deleted it immediately. It's a post or comment, but it's there in history, and even 9 years since we are bringing it back. So I wanted to hear from you. You're so afraid of the post. So what scares you? I'm not afraid. If I look back at my life, I'm not renouncing anything. It's part of my past, it's part of my experience. Whatever happened, happened. And the events, even traumatic events, make me who we are today. But I cannot now identify what's written there. It's not there. I have nothing to compare with. I've written much. It's out of context. I don't know what came before it, what after it. I don't know what was asked, what I answered, what I commented. It's just torn out of context. So you're saying there may have been 2 or 3 posts, some chronology, and this one is taken out of context, and you may have provided explanations before and after. Is this what you mean? Absolutely. So it's thrown out of context. Let's finish this. I know it's been 9 years since. Do you deny writing it outright, or do you assume, or can you allow it being written by you? I'm not renouncing, I'm confirming the fact that I did write a number of posts on the matter. I did write. The events did happen. I commented on them. And I cannot keep it closed in me. I cannot keep silent. These things need to be talked over, and I was talking them over because there was no official response from the government. The government stood idle, the law enforcement stood idle, and I was left alone with the problem. You don't know what you should have done, where you made a mistake. So I kept raising the question amongst the judicial community intentionally, but nobody really wanted to discuss it. So I did raise the question intentionally. I concur that it had happened. I have no further question. I have a question to Kateryna. In 2021, did you delete your Facebook account and create a new one? I'm a long-standing user of the social post. I had a few accounts. So earlier, you said you had one account. I have one account now, but you used to have several. I may have had 4 accounts. I take an informational break. I would delete an account and not revisit the account. Would you describe why? It's my right to take a break from the social networks. I suggest we can finish the interview. We've heard the answers to our questions and we could make our conclusions. Thank you. Now you can make an address to the Commission and the panel of experts if you would like to. Thank you. I would like to thank you for this challenging interview. I needed it too. I am among such esteemed society, and I had the privilege of discussing the matters that were never handled at the national level. I fully trust your decision. If you feel I'm suitable for the post, it will be a great honor for me to serve. If for any reason you feel I have not passed the test, I am still very grateful for your decision, whatever it is. Thank you. Thank you for your participation. All the best. We are announcing a recess in the